Maneva na sema PENDREAM TV. PENDREAM TV there osia dem yopo.
Things I was looking for to learn or to hear from the lawyers. Okay. One is if there is any precedent at all where somebody in our jurisdiction where somebody has been tried in absentia without appearing, not even once. Okay, because when I was
appearing before the investigative agency to
when I was looking out for some cases yesterday, I saw one that is in the Benjilo case. But even that one, the people appeared, they were granted bail, and then after they were granted bail, they absconded.
Okay.
And so I was hoping to hear lawyer say that, okay, there's this case where the person did not appear before any court, not even the investigative bodies, but was tried in absentia. But this one that I've not heard, he says he has not seen that yet.
He said he's not read that. Let's
okay.
I'm coming. Andrew Appia Dankwa is head of legal for the United Party. Thank you very much for your time. Good morning to you. I hope you're well.
Yeah, I'm doing good as well.
And that's the issue that Nancy is raising on the matter of Ken Ofori. Has our legal system ever dealt with something of this nature? Because the last time we heard about him, all this thing started with the special prosecutor says, I have some questions for you that I need you to come and answer. From then, we are now at the point of where they said they are going to try him in absentia. Have we had this before?
So good one to yourself, good one to your lovely listeners. When you say have we had this before, what exactly do you mean? Because there are a number of cases, there are a number of issues here.
Okay.
Are you asking about a trial in absentia or a situation where somebody who is on an investigation or is being charged for an offense has in very plain language has run away?
You see, that's a problem. It can be said that the man has run away whilst under investigation because he never appeared before the investigative agencies to even say these are your charges, this is what I say to those charges. He has never appeared before them. And then he is now going to be tried in absentia. So if you look at the series of things that have happened, have we had this kind of precedent before? Where the person
a trial in absentia.
Okay, a trial in absentia of somebody who didn't even appear before the investigative agencies.
Oh, well, you see, what we should have in mind is that there are so many instances of or criminal matters that we wouldn't know. We only know about them because of the person involved, because of the public figure. So, from where I said, I can't say for a fact that there is the first time something of this nature has happened. And when you take when you segregate the issues, let's say you talk about triumphs, it's happening. It's not like it never happened. Indeed, I know that probably the may be different, but then even in the case of statement large portions of the trial was an absentia. Yeah, you get a point. So for me, I don't think there's a novel matter. No, I think from what I said, I can't. I'll be making a mistake if I say this the first time. Well, like I said, every day so many cases are tried in this court. There are so many issues that happen, and so it's very dangerous for us to say that this is the first time this has happened. This is normal, and our law has made provision for same, and that's why I'm surprised that we're making a mountain out of a molehill. Because you see, when you settle the issues, let's say you are talking about the fact that he has Ken has acquired the green card, whether or not it's not in it. And my view is that it has not. But the whole idea of the extradition treaty, which was entered in way back in 1931, and which culminated in the Extradition Act, was meant to solve issues of this nature, where one persons who are not Ghanaian, probably are citizens of the United States, commit offense in Ghana or against Ghana at both. How do we get them to be prosecuted instead of the offenses that they allegedly have committed. Or persons who are ordinarily resident in the US who commit offenses in Ghana and get away. How do we handle them? That was the problem the Extradition Act was meant to solve. So for me, the fact that Ken has acquired the green card does not, in any way, in my humble opinion, impact the ability of the Republic to pursue him and seek justice for Ghana. Now, having said that, if for whatever reason that extradition cannot work, then they can also try him in absentia. And yet the requirement is that he must be granted notice. So the issue that is out of the country as well, because when you read our criminal procedure code, first are granted to the Republic to deal with issues where persons who have been charged cannot be served with the criminal summons. And the requirement on the law is that one, you try to serve him. If for whatever reason in his house, if for whatever reason you cannot get him, then you can serve anybody above 18 years old in the person's house. If that avenue is also not available, then you can simply place the summons on his house, a place where it's clear and legible, people can see. Then you'll be deemed to have been served. And once that requirement is done, and he is still not availing himself, then steps can be taken to try him in absentia. So for me, the only lies squarely within the confines of the state. In this case, the office of the special prosecutor, to do all in his power, accountability, to seek justice for them. For me, that's my personal.
I see. So you don't see a difficulty. There's enough. There's a lot the special prosecutor can take advantage of and then proceed with this matter.
Oh yeah. Unless clearly there is no commitment, like I have suspected all along, because these offences allegedly were done sometime in 2022. How is it that immediately they leave office, then access about the business? Really, for me, I think that it brings into sharp focus whether or not the manner in which the OSP was created serves the purpose for which an argument was made that it was created. But whether or not there is another example of the case of let's do something to represent something to deceive Ghanaians. Because you recall that in 2016, when leading up to the 2017 elections, I recognized that corruption was one of the biggest problems that we have been dealt with as a nation. And that the reason why we are unable to fight against corruption, even though in the 1992 Constitution, we made the principles of probity and accountability as being one of the cardinal principles underpins our constitutional democracy. And yet, corruption was killing our country. It was fundamentally hampering our ability to deliver the infrastructure needs of our people. But corruption was one of the biggest reasons why a country like Ghana is still unable to meet 30% of the requirement of the WHO, which says that any correct country has to have 5 emergency beds for a population of 1,000. And yet Ghana, we are still doing around 0.5. And that Ghanaians recognizes that one of the reasons why we still have schools on the trees was because of corruption. That one of the reasons why we have a hole worth $97.3 million, and yet we cannot deliver on Agenda 111. And see, this is even sad when you consider that to finish one Agenda 111 project required us to have about $16.5 million. How many of these Agenda 111 could have been built with $97.3 million? All the numerous conduct that has made this black star of Africa, meaning begging for redemption. And we cannot do that because of the evils of corruption. Because for all these reasons, why a case was made, why we had to create an office of special prosecutor, an office which was meant to be independent, because it's meant to be free from partisan constraints. And yet, in the manner in which this office has been created, the fact that it still needs the authority of the Attorney General, the same Attorney General that we felt that was under the influence of the President, but we need to create another body. And so if really we were committed to this agenda, we would have created a body that was truly independent. And that body would not be truly independent unless it is a constitutional creation. And we see evidence of this fundamental flaw in how it was created. In the fact that the office of the special prosecutor, for whatever reason, where acts supposedly were committed in 2022, and yet he only had the cojones to bring charges after the Akufo-Addo and left office. And they thought and watched, and Ken voted for the country. You get a picture. That's strange.
Are you suggesting that if there are any difficulties, it was the special prosecutor himself who caused it?
I'm saying that from how this matter is being handled, it gives the impression that the West is not truly free, that it's not truly independent. Because the government of what I'm saying is that offenses that are allegedly committed in 2022, the OSP did not have the cojones to raise issues with them only until Nana left power. That was defeat the purpose for which we wanted to create a body that was truly independent. Because for me, there's clear evidence of the fact that the OSP is independent. And to think that the way Emmanuel was created, he still is under the control of the Attorney General. And the Attorney General is a presidential appointment. He's there at the pleasure of the president. So how can the OSP be truly independent? Yeah, you get the picture. And so now, we should not forget that around June, the AG said that the OSP was frustrating their efforts to begin a traditional action against him. Do you recall that?
Yes.
Yeah. And also to think that the OSP has at its disposal the Criminal Procedure Act. And we are making a specific reference to section 62 to 65. He has available steps to take that will enable him to try Ken in absentia. And we've gone through a cycle. We are in June 2026. And we are having this discussion. Can you comfortably say that there's real commitment to prosecute Ken? Can you say that? Can go from where I see a fundamental lack of commitment.
But the OSP also insists that they've taken adequate steps to undertake the trial in absentia.
Who said that?
The OSP, in fact, they've given case trackers that shows that as at April, they were in court over the same matter.
But from 2022 to 2026, so is the vigilance of the sovereign, and then the sovereign is the people. That's what the OSP to act. But I do not see real commitment. And I do not see real commitment because of the structure and manner in which the OSP was created. If really we are going to win this battle against corruption, and if we all agree that the best chance of our winning is to have a body that is truly independent, then that independent body ought to be the creation of the Constitution and not by an act of Parliament.
I see. But you don't see any difficulties at all if the OSP is committed to prosecuting this matter?
Exactly. Because the fundamental reason why the Extradition Act was enacted Indeed, the reason why the extradition treaty was entered with the USA is to deal with such issues. That if, for whatever reason, a citizen of America commits an offense in Ghana and which is also an offense in the US, and that person is finds himself in the US, not in Ghana, then we can fall on the extradition treaty which culminated in the Extradition Act of 1960 to bring that person down and try the person. Say for if the person is a resident of the US. And so the law is available since 1960. Indeed, the treaty says 1931. So why should the fact that Ken has a green card scupper innocent? Because we have laws available to deal with these issues. Two, we also have law that gives a justification for trial in absentia. So then so where lies the problem? For me, I do not see any problem. They should not go down. They should fall on their commitment to the principle of probity and accountability and ensure that justice is done Ghana. That's all we ask.
What if we are forcing them into action that they may not have taken if they had spoken to Ken? Because, in many cases, you've represented persons who are subject of criminal investigations before, where you take your clients to the investigative bodies, they answer the questions adequately, the investigative bodies are perhaps satisfied and decide that we will not bring charges against them. That in this case, this may have been the case if only they had opportunity of speaking to Mr. Ken Ofori.
Well, that opportunity was not had. And that opportunity was not had not because they failed to give Ken the opportunity. You understand? So that opportunity wasn't had. And I'm not an investigative body, but for them to have charges, because you want to understand that all criminal charges, but about 90% of criminal charges, the crimes that we call crimes malign. Generally criminal law device or criminal justice divides crimes into two. Have crimes that are crimes malign. So those are crimes that necessarily require what we call a negative state of mind. And we have crimes malapropita. And crimes malapropita are crimes that are acts that are by themselves prohibited. And you don't need to have any negative state of mind before they become crimes. Now, I'm sure that in terms of the act, and so all crimes malign have two components. That's what we call the absolute loss. So absolute loss is the act itself, and then the negative state of mind. And so most of the time, where explanations help is when it matters on whether or not there was that negative state of mind or not. They have done their investigation, and these and most of these cases were on documentary evidence. You will get a picture. So, for me, if Ken did not take advantage of going to explain before the prosecutorial body to the extent that could give them a fair idea of whether or not they had the requisite negative state of mind or not in the commission of the alleged offense. That is what
I see. Lawyer, thank you. Thank you very much for speaking to us. Lawyer Andrew Appia Dankwa is head of legal, United Party, joining us on the line. He says he does not see a problem here. No problem. That there are adequate laws that should help our Office of Special Prosecutor to be able to go through this process seamlessly. That they've also missed many opportunities. We're just trying to explore whether there are any difficulties when it comes to the matter of trial in absentia. Lavo, you seem to have researched this to some point. Yeah. You are not a lawyer. Sometimes you sound like one.
I think, like the lawyers pointed out, Ken is wasting our time. Sorry, OSP is wasting our time.
Okay, wasting our time.
Yeah, OSP is wasting our time. And to be able to come through with trial in absentia you need to get the buy-in of the court. Just ensure that you are able to produce enough evidence to convince the court that, based on the conduct of the accused, you think that the ground is set for trial to happen in his absence. And there are two major hurdles to overcome in getting the buy-in of the court, which the lawyers have pointed out, but let me stress it further. The first hurdle is service of court document, which is something the OSP has not done. I don't know why up to now OSP has not been able to serve the court document on Ken.
But it seems that's part of the process that they are undertaking in court currently. Because if you read the tracker, that's the heading that they give to what they are doing in court now.
Really?
Yes, that's my understanding of the heading I read. And I'll find that, but continue.
Okay. So the OSP ought to have demonstrate seriousness in trying to serve court. And our laws have spelled out what to do if you are trying to serve court document on an accused person who is not available. I don't see the court being the obstacle here. The court cannot prevent or put impediment on the way of OSP from serving the accused. So that's the first. The second thing is that Ken is not in the country. That is what is making it difficult. And it is always difficult to serve accused person when they are not in the jurisdiction. So another thing is, without proof of service, fair trial may be violated, and the court will not proceed with anything that has to do with trial in absentia if there's no proof that you've served the accused. So proper service is most significant obstacle when it comes to trial in absentia. The second hurdle is proving voluntary absence. This one, I think we don't have a lot of problem here because it is very clear that Ken voluntarily does not want to show up for this. At the beginning, we were told that he is not well, he's gone for medical treatment and all that. And OSP gave them time. He requested for 3 months, and OSP gave them 4 months or 6 months. That time elapsed. Another extension was given. That one too elapsed. Now, what happened with IC? Ken was arrested recently. Involving
ICE. It was immigration issues.
Good. What happened during the immigration issue clearly shows that Ken lied about his health status. If Ken was really unwell, as he made us believe in his interaction with OSP, I'm not sure we would have seen what we saw during the ICE case. It was clear that this is a man who is okay. We saw him in court. I think he was detained, right? There was an issue of detention.
Yeah, he was in the detention.
Exactly. So if he is a man who is undergoing serious treatment for which reason he cannot travel, I'm not sure ICE would have picked him up and then detain him. So clearly it is evident that Ken voluntarily doesn't want to come. So OSP has the second hurdle has been crossed already. There's enough evidence to show the court that this guy doesn't want to come.
Based on what we saw.
And I don't know why OSP is not saying anything about these. So there are two hurdles to cross. One is to serve him the document. There's legal provision that if the person is not available for you to serve him, you can go and paste the notice wherever. There's that. They've not done that. And then we've seen voluntary absence. He doesn't want to come. He's doing what he has to do to not show up. So I don't see why OSP should drag this. The ground has been set for trial in absentia to happen. What is lacking right now is the willingness of OSP to take the action. Yes. So that is how I've seen this.
I see. Very interesting. Nancy, you were, in fact, the thing you said was you were trying to understand whether this has happened before. From both, even listening to that, David Amatepe, you get clarity as to what the two problems are and how the law helps or procedure helps deal with those two problems. So it means that the OSP still do not have an issue. Then there's the case of Leandro Appia Dankwa, who is clear that no, there's no problem at all. If the OSP wants to do it, there's a clear road to follow. So now, are you convinced?
So if all the circumstances that they must, all the things that they must show to say that, okay, so we've tried our best to bring him to come and attend to court, and he's deliberately refusing to come. If they have all that to prove to the court that they've exhausted all the legal, all the lawful avenues, then why not? Let's proceed, because maybe, I mean, the general rule says that the person must be present. But now we have come to know that there are circumstances under which the court allows for trial to go on without the presence of the person. And so if those can be justified by the state or the special prosecutor,
then there shouldn't be a problem.
There shouldn't be a problem. But the few questions that are rising in my mind, and the first one is, at what point does an accused person's absence become obstruction of justice?
Where the accused is obstructing, where you have a deemed the accused to be obstructing justice.
Justice, yes.
Justice for who?
I mean, justice delivery.
Okay.
Yes.
Okay. Okay.
It's one of the things that is in my mind.
Okay.
And how long should the state wait before asking the court to proceed without the accused person? Is also one of the things that.
Is it the because if you listen to the lawyers, it doesn't seem to be an amount of length, a question of length of time. It's about the question, because it all seems it comes down to the court. The court's role is to the extent possible, ensure that the constitutional provision of fair trial and also giving the accused person adequate opportunity to defend himself.
Okay.
So I think that the question is, have we done enough to offer this man the opportunity to defend himself? If we have, then I think it proceeds, no matter the amount of time we are talking about.
I think we have.
Okay. Then you talk about fair trial. Then it also brings me to the question of if we go ahead with this case in the absence of Cain, will it strengthen the confidence in our justice delivery system or raise concerns about fair trial or fairness?
I think it will rather strengthen it. People will know that if you run away after committing a crime, you can be tried. We don't need you to be in the country to try you. Okay. Once it is evidence that you are running away, you don't want to be present. And then secondly, you are avoiding being served. And we are using legal processes to serve you. The grounds are set, the court to take it. The court just needs you to prove these two things. Is he willingly avoiding coming? 2, have you served him? If the answers are yes. If the answer is yes, then we can try you in absence. So it strengthens the justice system.
Because don't forget that in courts, they use different languages. You were deemed to have been adequately served. Deemed. It doesn't mean that they have found it. And you see, then they will also say that we've made enough efforts to ensure that he has the right to defend himself. Once we've gotten there and the court is satisfied, the issue of the trial not being fair becomes the burden of the person. So if we have found you guilty, all of a sudden, then you find your way back into Ghana and taking us to the Supreme Court. Now you have to show to the Supreme Court that these two things were not satisfied. So the burden falls on you to do that. So I think that once the court agrees, then there's no problem.
Yeah, good to know.
Please, animal rights lawyer.
Yes, sir.
I think one of the biggest challenges you have with animals is catching them to appear before the... Do you need the animal to be present whilst the matter is being...
Oh, that be. Say, you will more be brave, so. And say, a one and casa or committee, you can still continue.
Because catching them is not easy.
Yes.
Okay.
And more especially.
Is that trial in absentia, or it is they have gotten to the point where you admit that it's difficult to catch animals?
Oh, per se, but you are not getting it. to try be baku mienu na onsa enka then what work is in so definitely when him say kianiki so be enkuni nko ade a
no abewu.
Let me see. So, if an animal gets involved in an issue, are you serving them?
What?
Do you serve them that they are these proceedings are given?
Yes, serve unano.
Okay. So in this case,
yes, serve unana de abuana aba.
So when the owner denies that it is his or her animal,
na say the other case nearby e wo gidie say yes, abua we na a committee such offense, then we go after that abua. Yeah.
Do they have the right of self-defense, or it all goes back to the owner of the
unana my self-defense? And only the way.
Like if you say that the goat has come to eat your cassava, how would the goat defend himself?
And I make I say unano.
Anyway, say na punch in a ray, and saying, and not the arena, or Korean, any man so say, no, a punch no very idea no. On when none helpful, now you see, on my discretion. Okay, I just am on an area idea. You know, your year.
So you are a lawyer for domestic animals. How about the ones in the bush?
Okay, so what do you do in a case when it's a stray animal? You can't find the owner in it.
Everything say or what say. Or was it the case the day?
Because it's difficult to find. They all look the same.
What does they have owner?
No, one of the biggest problems with them is that they all look the same. It's difficult to differentiate between them.
I see.
So if it's what they call it, the famous one, the most popular one, the green. The green one that we deal with.
Python.
No, not a python, the smaller one. Oh, you don't know snakes. Okay. I don't know why I've forgotten the name. I used to know their names. So let's assume that it's a cobra.
Cobra. Hey, cobra is one of our guys. You cobra.
You take it like that.
That's another than a go for cobra. I'll be using man. Oh, yes, say,
well, let's deal with that business.
I don't be
as in Kofana, I'm sure interest say at least they will get the 2 bedrooms for me. They've all gone into admission. Okay. Be like that.
And I'm bomba.
Abia. Say Jordan Obeba.
Yeah.
Okay. The lawyer David Amatepe sent me this says, my research now clarifies the issue of plea in absentia.
Okay.
A not guilty plea is entered as if he refused to plead. Okay, so you enter a not guilty plea on their behalf.
Okay.
Yes. Because even when the person pleads guilty, they can still enter a not guilty plea. Yeah. There are many occasions where, Lord, if you don't have money, you die. Anyway.
Well, are you looking to own a premium home in a prime location in Accra like me? Then SNIT invites us to explore its luxury apartments and townhouses featuring spacious 2, 3, and 4 bedroom units across selected communities in Accra. Choose from Adinka Heights in Cantonment, Eagles Place, and Royal Tivoli in Sakumono, and then the Meridian Gardens in Klagon for your next home. Experience comfort, style, and value backed by a trusted institution. Units are now selling. So call these numbers or this particular number 0244 593 276 0244 593 276 or visit SNIT sales office at the 6th floor, Rich Towers, Accra for further enquiries. You can get yourself 2, 3, or 4 bedrooms.
Okay.
In Accra, the center of the capital.
I was doubting it when it came to mind. The snake matter is a green mamba. Our friend who is a police officer has sent us the name. Yes. So when we are finishing police officers, I always tell you that they are listening.
Mame fa na se ma PENDREAM TV. PENDREAM TV de o se dem yopo.